Bob Bianchi, and we have breaking news. We have a not guilty in the Kachinsky case. This was something we've been debating. I've been on with Gene Rossi. I mean, and having Gene Rossi is like a full plate because he's got a full boat of knowledge. But to add to that, the force multiplier of the great, stupendous, magnificent, intellectually brilliant Aaron Keller from the Law&Crime Network literally sits right across the table from me. Aaron, welcome.
Bob, good to see you. You know, I don't know how to respond to that kind of introduction, but thank you.
Well, thank you. It's an excellent response. Aaron, listen, I know that you've been following all permutations of this case, especially because Kachinsky actually represented Dassey in the making of the murderer case, and nobody knows that case better than you inside and out. I just want to ask you, generally speaking, as you know offline, and I've been saying to Gene, I don't see a guilty verdict in this case. The jury comes back not guilty. Aaron, is it your sense that this was a politically motivated prosecution?
You know, I've wondered that question. I'm not there locally to sort of read the temperature and the wind in northeastern Wisconsin these days. But look, the bottom line is people who watched Making a Murderer wanted this guy's head on a platter. I've said it before, I'll say it again. So a lot of people were watching this case hoping to see some karma-like retribution for this perception that he was just a horrible attorney for Brendan Dassey. And look, I understand those criticisms. But this is a case about these specific charges. I thought the cross-examination of Kachinsky was weak. I thought that the state's case here was not horribly strong. And look, I understand having sympathy for people who are victims. I understand having sympathy for people who purport to be victims. In this case, though, we just watched him get up on the witness stand. And usually, you know, Bob, that that's dangerous. But he got up there and say, wait a minute, she's complaining about me commenting on her tan. She used to email me and say, oh, I'm working on my tan on the beach. Okay, well, you know, how do you want it here? If you're going to sort of open that door up into that kind of language, then to complain about it on the back end, juries are going to struggle with that. And that's exactly what happened here.
Yeah, and to that point, Gene, you know, as prosecutors, we have to evaluate and pull the trigger and be measured in what charges we bring based upon cases on a case-by-case basis. Some have said about this case, I'm not saying I'm saying it, but some have said this actually depreciates or deprecates stalking cases of typically women, but it's men too, who are real victims of serious stalking, and the reason why that law was put into place. And this was a much minor offense where she could have gotten redress and recourse on a much lower level without asking to try to put the guy, convict him of a charge that could carry 3.5 years in jail for a guy who's never been in trouble before.
That's a very good point. The motto that, you know, when you bring weak cases, it in the end hurts the ones that are strong, because the jury and the judges will be very skeptical. And I've seen where we brought relatively weak cases on a certain topic, like gun cases, and then when we brought a strong one, they didn't give us that benefit of the doubt that they usually do. So that's a very good point.
Yeah, and you know, Aaron, it also, I've said, you know, sometimes can victimize a victim a second time. I'm not saying that this woman didn't have reason to be concerned or have a bad employment relationship. She had a right to make sure she had a place that's free of hostility and a workplace that's safe. But, you know this guy, I think, better than anybody, certainly here in the Law&Crime Network. The argument from the defense here was that this is Len being Len. Len meows. Len goes and salutes every flag that he passes. Len cleans off people's snow off their cars. He does weird things.
Yeah, I mean, okay, look, and that's exactly what this boiled down to. In the end, I think the jury looked at this, and a guy got up there on the stand. He had some reasonable explanations for some of the more serious things that he was accused of doing. But exactly, that's it. He's been a socially awkward guy more than once. And even when I would call some of the local police departments up in northeastern Wisconsin, when these charges were filed, I remember hearing this kind of discussion from the local cops saying, well, you know, we've always known Len, and he would do these little bizarre things. But do people take him as a nefarious guy? Well, not really. Not up there. They just know him. That's the way he is. And he, you know, does his job. He is recognized. He shows up. He goes to work. And that's Len.
Okay, listen, that's great analysis, and that doesn't make you, because you're a little kooky and a little eccentric, it doesn't make you a criminal. Sometimes it makes you entertaining. In fact, I found myself smiling looking at his testimony just by his demeanor. I don't know why. Gene Rossi, real quick, let me hear your best meow. Come on.
Meow.
Aaron, do it.
Oh, boy.
Let me hear it.
I'm good
Come on,
at
bro.
it,
I'm going to do it. I'm gonna give you one.
I can't do it when I'm laughing.
Come on. Dude, that's... See, now I'm not going to do it because I'm embarrassed of mine. Mine's meow.
Wow.
Aaron, do it one more time, but you got it.
You know, you're going to charge me with stalking you if I make this noise one more time to you.
Aaron, you can meow me anytime. Hey, guys, listen.
Gosh.
We love to have fun here at the Law&Crime. I am impressed that you came out with that realistic meow. Aaron, you always are amazing. We're going to go to break. We'll be back on the other end. Okay, guys, we have just gotten the verdict back in the Kachinsky case. We're going to take a look at that again. I got Aaron Keller with me and Gene Rossi, so it's a great opportunity to break this case down. So let's take a look at the verdict.
All right, ladies and gentlemen, the court has had an opportunity to review the verdict, and I am going to read the verdict to you. I would ask that you each please listen carefully to the verdict as it is read, as I will then be asking each of you to affirm the accuracy of the verdict I have read and whether it is your verdict and the verdict of the jury as a whole. The verdict reads as follows. We, the jury, duly impaneled, find the defendant, Leonard D. Kachinsky, not guilty of stalking as charged in the second amended information, dated today's date and signed by Ms. Heilman.
Okay, Len Kachinsky found not guilty. It's been a riveting case, riveting verdict. Now, look, we have a little fun because you got to have gallows humor when you do this kind of work. And, you know, Aaron, I was talking to Gene before about, in a certain sense, I don't disbelieve this victim, this woman, at all. I believe that she is an accurate reporter. The defense, I don't even think, was really suggesting that she wasn't an accurate reporter. I believe that there were employment law issues that were going on there, that certainly there were some things that he did that would cause concern for an individual. You could tell by the way she testified she was being truthful and she was emotionally moved, as we see a photo of her right now, crying. There were certainly creepy things about leaning over that desk, the envelope with the blood, telling her she knew where all the family members were and things of that nature. So I'm not saying she hasn't been victimized. I just don't think the state had enough evidence to prove that kind of case beyond a reasonable doubt to 12 people.
I agree, exactly. Look, I mean, and as I said before, I don't want to make light of the situation that she went through because clearly she was bothered. But again, the statute requires a look, not just at whether she was bothered, but whether a reasonable person would be bothered. And I know that this isn't necessarily relevant, but well, it is actually, because the defense brought this up. The defense brought a number of witnesses, promised to bring them, and say, this is just Len. This is who he is. It doesn't bother anyone else. And, you know, one piece that I keep going back to here is that she had a relationship with him on Facebook before she was hired by him, as I understand it. And she was complaining frequently about another supervisor, saying that that supervisor led her to go home crying all the time. And you know, so he kind of took her under his wing and promised this so-called happy place. It's a phrase that they used to use. And then all of a sudden now she's got a problem with him. And you know, look, the defense uses that to turn around and say, okay, the statute requires a reasonable person standard. That's every man, the average person. Would the average person really be this worried? Would the average person suffer extreme emotional distress from this kind of conduct? And that was the sticking point for the state, I'm certain of it.
Yeah, and the other thing, too, there, Gene Rossi, to add on to what Aaron just said, because we kept getting into that law, as Aaron aptly puts, but it also requires that the defendant knew, okay, or reasonably should have known that the conduct was going to be that way. And I think Aaron makes a really good point, Gene, that you have to understand this in the entirety of the history of these people. And I think some of the emails the prosecution introduced actually went to the fact in favor of the defendant that he's like, we need to normalize our relationship.
Aaron brought up a good point. It's sort of like caveat emptor. When Mandy, the victim, was Facebooking him and knew that he had this odd, eccentric, very weird style, she willingly became his employee and his clerk. And so it's caveat emptor. She knew what she was getting into. So, Aaron, you brought up a very good point, and that's one of the elements. What a reasonable person who allows himself to be hired by someone whom they know is odd, quirky, and eccentric, they shouldn't be surprised that he does odd, quirky, and eccentric things.
No, well, Gene, I'm going to throw a question to both of you guys, but let's start with you, Gene. again, I have felt that the evidence here just was not going to meet that beyond a reasonable doubt standard, and the elements of the offense, as Aaron just pointed out and I supplemented. Do you think, if we could just put our world of hypotheticals out there, if you only had to prove a case by a preponderance of the evidence as opposed to beyond a reasonable doubt, could the state have won the case with that standard, or was there more to it than that? They just weren't going to get there, period?
Guilty if it's preponderance. I think if this were a civil case, they'd have no problem proving if it were stalking, and you only had to prove 51%. No doubt, 51%, absolutely. But that's the beauty of the criminal justice system. It has to be beyond reasonable doubt. I say it's always roughly 90%. And no one can say with 90% certainty that he intended to stalk her, that she reasonably thought it was stalking, and that he wasn't making communications to her to try to improve their relationship.
Yeah, Aaron, I just want to take a twist. Actually, you were kind of emailing me during the course of the day. The government started out with other charges, including harassment, and then eventually dropped them prior to the trial for strategic reasons. Can you tell the audience about that?
We don't know a lot other than that, Bob. The bottom line is this was a felony stalking case. Underneath that were 2 charges, misdemeanors, for violating the restraining order. The prosecutor dropped those 2 misdemeanors a couple of days before trial. We called up and said, why is that? And the only response we would get back is strategic reasons. Now, why could that be? Is it because the state knew that this case was a little bit weak? Well, I would hope so, because otherwise the prosecutor wouldn't be looking at the mountain of evidence that makes Len Kachinsky look less than criminal in this case. Is it because of that? Is it because the state didn't want to risk a split verdict here, where jurors would turn around and say, well, some think he's guilty, some think he's innocent, and they go for the lesser charges to split the baby, as we discussed? Is that a possibility? The state wanted to force jurors to look at that top charge. That's a likely possibility. It also makes me wonder if they could come back and try to hit him with those misdemeanors again. But we get into all sorts of double jeopardy questions if we even try to go there. Is it possible? Very slim chance, or unlikely, I would think. Would you agree?
Yeah, I agree. I think that, first of all, it was charged. They voluntarily dismissed it. The factual basis is emanating from all those charges is a core same thing here. I don't see them moving forward on jeopardy. I'll throw it to Eugene on your opinion about that. And also, if you can comment, I think the prosecution was afraid that the jury would be inclined to do the misdemeanor charge, and they weren't satisfied with that. What do you think?
Yeah, let me address the double jeopardy. I don't think we have a double jeopardy issue here, because the jeopardy did not attach to those 2 misdemeanor charges. That's number one. And of course, jeopardy attaches when the jury is sworn in, or in a bench trial when the witness is sworn. So they can bring the 2 misdemeanor charges unless they were dismissed with prejudice. I doubt they were. Now, what was your second question, Bob? I forgot. I'm sorry.
Geez, you know,
are they lesser, Gene? Are they lesser included that are attached to this? Because that was where I think I was going, and I probably phrased it the wrong way.
Yeah, under a case called Blockberger that was overruled by Carlin, and that was brought back by a case called Felix. You look at the elements, and the elements of the stalking case are vastly different than defying a judge's order. So you wouldn't have a double jeopardy case on elements. So that's another reason why the double jeopardy clause would not be violated.
You know what? It sounds about right, Gene, but there's something in the back of my head that says, except if you charge them or the case is indicted and you choose at the trial to drop or dismiss those charges. I don't know why, something in the back of my head. Certainly a good question to ask, and I think it would be unfair, Aaron, at this point in time to do that. We got 30 seconds or less. In general, I mean, do you think a fair verdict? Do you think a right result was reached?
People are going to skewer me for saying this, but I think based on the testimony that I saw coming out of Len Kachinsky, I think this was the proper verdict. And I know that I'll get hit from a lot of people who wanted the guy's head on a platter because of making a murderer. Again, this is a case in a court of law where the state has to prove very specific things. I don't think the state got there.
What do you think, real quick, Gene? You got 10 seconds. Do you think that the right thing happened here in terms of the evidence?
Yes, because if you compare Mandy, who I think was definitely harassed by preponderance or even by clear and convincing evidence, his testimony really saved the day and that's why he was acquitted.
All right, Gene Rossi, Aaron Keller, thank you guys so much. I got to go off. We got another segment of the show. Stand by. I'll be back Wednesday, 12 to 3. You be well.